This video is made for educational purposes only and cannot be taken as legal advice. In this video we are going to take a look at a Court of Appeal judgment of a UK police officer appealing his sentence of 10.5 years, only to get it increased. On the 28th of October 2020, Timothy Brehmer was sentenced by Mr. Justice Jacobs at Salisbury Crown Court to 10.5 years imprisonment for the manslaughter of Claire Parry. The offender had been charged with murder. He had pleaded guilty to manslaughter at the plea and trial preparation hearing and later, in his defense statement, advanced the case that whilst guilty of an assault he lacked the intent for murder, unlawful act manslaughter. He was tried for murder. The judge left the partial defense of loss of control to the jury. The jury acquitted of murder. It fell to the judge to decide on what basis of manslaughter to sentence the offender. The judge was satisfied so that he was sure that the offender had the necessary intent for murder but lost control for the purposes of the partial defense. He sentenced the offender having regard to the definitive guideline of the Sentencing Council for manslaughter following loss of control. He concluded that the appropriate sentence was one of 12.5 years imprisonment before a discount for the guilty plea to the different type of manslaughter. He applied a discount of a little over 15%, which resulted in the sentence of 10.5 years imprisonment. The 41-year-old offender was a police officer who had been having an on and off extramarital affair for about 10 years with Claire Parry, who was a 41-year-old nurse with 2 small children. Her husband knew of the affair and was contemplating leaving her. In early May 2020, Claire Parry decided to tell the offender's wife about the affair. Internet searches had led her to conclude that the offender was a serial womanizer. She told the offender of her intention, but he did not take the opportunity to tell his wife himself. On the evening of the 8th of May, the offender was on a night shift and spoke at length to Claire Parry. He left work at 6:45 a.m. on Saturday the 9th of May and spoke to her again. She was angry and the offender believed that she was on the point of telling his wife about their affair. Claire Parry was due to start a shift at 4 p.m. that afternoon. She sent the offender a message telling him to meet her at the Horns Inn pub car park at 3 p.m. The offender found a pretext to leave home and arrived at the car park. Mrs. Parry arrived and got into the offender's car. A text message was sent from the offender's phone to his wife which read, "I'm cheating on you," that was sent by Claire Parry. Calls and texts that was sent from Mrs. Brehmer in response were ignored. The offender reset his phone, thereby removing all personal details. There was a fight in the car, but precisely when it started is unknown. The car was parked out of sight of CCTV cameras. The offender was recorded by CCTV walking across the car park to the entrance. He had 3 knife wounds on his inner left forearm with bloodstains on his shorts and shirt. He spoke to a passing couple and told them he had been stabbed. One phoned the emergency services. He said nothing of Claire Parry. The other looked around the car park and found her body lying half in and out of the driver's door. Her face was blue with blood coming from her mouth. Both witnesses thought that she was dead. Although her heart had stopped, it was restarted and she died in hospital the following day. At the scene, the offender said that it was Mrs. Parry who had stabbed him. The penknife used was in fact his and kept in the glove compartment of the car. He was arrested at the scene. There he said he might have stabbed himself to get Claire Parry's attention. In interview the following day he accepted that he had stabbed himself. The offender's account of what occurred after the text message was sent at 15:02 was that he and Claire Parry continued to talk. She was in the passenger seat and he asked her to get out of the car. When she refused, he said that he tried to hoist her out of the vehicle. It was during this struggle that he had applied pressure to her neck, not realizing what he was doing. That resulted in her death. The prosecution's case was that the offender had become angry when the deceased had sent the text message to his wife, at which point he must have strangled her. The evidence of the pathologist confirmed severe injury to the neck with a fractured hyoid bone and damage to the cartilage to the right and left of the larynx. There was deep internal bleeding and bruising in the neck tissues and bruising near the jawline. There was multiple evidence of asphyxiation. There were two mechanisms that might have caused the injuries, either using the crook of an elbow as a fulcrum or by putting the forearm across the throat. The extent of the injuries was such that the minimum period of compression was between 10 and 30 seconds. It was this that led to asphyxiation and starved the brain of oxygen, which killed Claire Parry. There were 31 separate sites of blunt force trauma on her upper body. These were made up of 9 areas of bruising to the trunk, 11 areas of bruising on the upper right arm, 10 areas of bruising and abrasion to the left arm, and an area of bruising and laceration in the mouth. The prominent areas of bruising on the arms were consistent with grabbing actions and the injury to the mouth with a blow. It was clear that Claire Parry had fought back hard to resist the violent attack of the offender. The offender gave an account of events which did not explain the neck injuries. The judge referred to the moving victim personal statements in this sad case, which gave details of the impact of Claire Parry's death on her children, immediate family, and more widely. He concluded that the qualifying trigger for the defense of loss of control was only just met, with the consequence that, for the purposes of the guideline, the starting point was 14 years imprisonment, with a range of 10 to 20 years. He identified 2 aggravating factors. First, Claire Parry endured significant mental and physical suffering and would have appreciated that the offender was killing her. Secondly, the offender's conduct in the immediate aftermath of his violent attack. He sought to blame Claire Parry and accused her of attacking him with a knife, a lie in which he persisted until the following day. As a policeman, that was especially reprehensible. In mitigation, the judge accepted that the offender was a man of positive good character in serving the public, that he was remorseful, that the offense was not premeditated, and that as an ex-policeman he could expect a difficult time in prison. He also took account of the current restrictions in prison resulting from the COVID-19 pandemic. Discussion. The judge approached the question of how to sentence the offender meticulously by reference to King. The verdict of the jury left open the possibility of 2 types of manslaughter: unlawful act or loss of control. If he was sure of one of those types, he was bound to sentence on that basis. If unable to be sure of either, he was bound to sentence on the more favorable basis to the offender. The judge was sure that the offender was guilty of manslaughter by reason of loss of control and was therefore right to sentence him on that basis. There is no doubt that the evidence admitted of that conclusion. It was left to the jury. We are unable to accept Ms. Martin's core submission that the judge was bound, on the evidence, either to accept that the offender lacked the intent for murder or be unsure on the issue. Conclusion. Having had the benefit of argument which was not available to the judge, we conclude that the offender's plea to unlawful act manslaughter did not justify a credit in the order of 15% for 2 reasons. First, as the guideline expressly says at F2, where witnesses are called during such a hearing, it may be appropriate further to decrease the reduction. This supports a conclusion that a reduction of 15% was excessive. However, we also bear in mind that, unlike a Newton hearing where the factual basis for the plea of guilty is in issue, in this case the appellant pleaded guilty in July 2020 on a radically different factual and legal basis from that upon which he was to be sentenced. We accept that some credit is justified because of his acceptance of criminal responsibility, but conclude that it should be no more than 10%. In the result, the sentence in this case should be one of 13.5 years imprisonment. We grant leave to the Attorney General to make a reference to the Court of Appeal. We quash the sentence of 10.5 years imprisonment and substitute a sentence of 13.5 years imprisonment. The application for leave to appeal against sentence is dismissed.